Welcome. Thank you for joining us. I'm Rebecca Berger. This is Justice for All, where you get to hear from legal professionals in the surrounding area. Tonight we have a really great guest, Ernest Bernabei from Pillinger, Miller, and Tarallo. Ernie, welcome. Thank you for joining us.
Thank you for having me.
I'm
Appreciate
glad
it.
you could be here from your very, very busy schedule.
Yeah, despite the pandemic and everything, it has been very busy. I mean, we've been increasingly busy, so that's a good thing.
Well, you do a lot of litigation cases, so
yeah. I mean, I'm a litigator, and more importantly, I'm a trial lawyer. I mean, I've tried probably 250 so cases to verdict over the course of my career, which is unusual. I mean, a lot of people say they're trial lawyers or they're litigators, and they really don't go in the courtroom. So there's a small group of us that do that, and so, you know, that's really been my career in a lot of ways.
And it's such a skill. Like I think what people get wrapped up in is seeing Law and Order and thinking that you can, you know, or some other crime show or, you know, courtroom show, thinking that that's really what can happen in court, not understanding there are certain rules of evidence, court rules that you have to follow. So it's not exactly what you see on TV.
Exactly, and you know, it's sort of, nobody likes to watch TV with me when there's a show like that on, because, you know, I make objections on things too, and I comment on things. They're like, we don't need to hear that, just enjoy this show. You know, things like, things don't get to court in a week, you know, and people don't get to make like running speeches and statements while they're asking questions, and none of this business about, well, I withdraw that question after you just asked like a 10-minute question. I mean, so these kinds of things can become a little annoying.
Or doing speaking objections where they go on for about 10 minutes and then finally getting to the objection.
Exactly, yeah. I don't want to get into too much about speaking objections because, you know,
well, every once in a while it's necessary. Every once in a while, depending upon who you have as an adversary, sometimes
and
it's
a judge,
necessary.
Yeah.
That's true.
Yeah.
So did you always want to be a trial lawyer?
Yeah, I think I did. I mean, my history is, you know, I'm a Philadelphia native. I went to Friend Select School, and then I went to University of Pennsylvania, so I stayed in the area. I went out to Dickinson for law school when it was the oldest independent law school in the country. And, you know, my experience was I always enjoyed history, politics, debate, and I was in plays, so I did drama, but I also competed in athletics as well. So I had that competitive streak combined with the speaking and drama and so forth. So I think that made sort of a natural progression to do trial work. You know, I have no interest in just sitting around doing paperwork and so forth, but fine, power to people who want to do that. But that's what I've always wanted to do. And I've been fortunate because I really had the chance to do it early on. I had a chance to really start early, and people put trust in me, and I got to try a lot of cases over the course of my career, really from the very beginning going forward. So that's been good. You know, I've been with Pillinger, Miller, Tarallo for 5 years now. I've been in practice 36 years. And I really came to the firm because they were looking for somebody to be a trial partner in Philadelphia, New Jersey, to really try cases and to oversee cases. And it's been a great fit because what attracted me to the firm is there's a lot of really good professionals there who really know their stuff. They're experienced in litigation, they understand the numbers and the strategies, and they have some unique things. I mean, I know you had my partner Jeff Miller was on.
I did. He was great.
And you know,
he does a lot of the.
He's a very
ADR stuff.
You know, he's very exceptional in ADR and mediation and so forth. People like Jeff who do that kind of thing are a good combination with people like me who do the trial work, because we know most cases settle, but sometimes you need somebody to take it to trial or be ready to take it to trial. And with our firm, they have what's called a roundtable, where we get a case and a group of the most experienced people look at these cases and give evaluations on strategy, on numbers, on damages, on verdict value, on settlement value, and so forth. So the clients really get the benefit of all of us who've done a lot of this stuff, really giving them the strategy and the numbers. And it's not something that we charge, oh, there's a big round table, let's bill eight people. No, we just do this as a service. It's part of what we do. So that's been really, really good, and I was attracted to that with the firm.
It's almost like a focus group with attorneys.
Exactly. It's like a focus group is exactly what it is. And it really sets the tone and gives the right kind of numbers on cases. So that's been really excellent, and that's something that we really have offered people. We've really, it's been a growing firm too. I mean, we when I started, probably somewhere in the 50s, and now we're about 100. So
Wow.
it's been growing. We've gotten 9 offices now. We have a lot of great people all around, and Pennsylvania, New Jersey has been terrific in terms of its growth. And you know, we've had a chance to really, I've had a chance to really work with a lot of great professionals in that sense. And
Well, you have such a round, diverse group of individuals,
right.
And different types of attorneys. And what you do all types of cases. It's not that you're doing just one type of cases, you're doing
Right.
a variety of litigation, which I also think is helpful, you know, in any firm, because that experience alone, you know, you've handled malpractice cases,
Yes.
you've handled construction cases, you've handled mass tort cases. That variety and that experience alone is so valuable, particularly when you're dealing with someone's case on the defense perspective, because you work on the defense perspective,
Yeah.
to try to figure out, where is this case going? What number are we going to put on this case? And do we need to take this case to trial?
Right. I mean, when cases come in from the beginning, I mean, what I think is important, and what we try to do, and what I try to do is, you know, really set a strategy from the standpoint of, I'm going to be the guy in the courtroom. Okay, I understand. I've done this a long time. Most of these cases are not going to go to the courtroom. They're going to settle. But we have to be prepared. There will be certain clients that I have that want to take a case to trial. And so I'm going to do that for them. But there's also going to be most of them that are going to want a realistic assessment of the case. And when we use the round tables and other things, we do that. But we set strategy early. And I don't believe in getting a case and saying, okay, I can bill the hell out of this case by doing all these motions and all this paper and all this kind of thing. I think it's important to understand that we want to do things strategically. You know, I want to, if I file a motion, it's because I think there's a reasonable chance of success and it's going to move my case forward. If I do some kind of a deposition or some kind of an event in that litigation, and even at trial, I want to do something that's going to move the case forward in a positive way, not just generate a lot of fees. And it's because you're doing nobody a service. And you know, I'm not interested in being what I like to call a paper tiger. It's just generating paper and generating paper and focused on that. I mean, I'm looking at this as, how am I going to get this to a position where it's going to be going to trial?
You want to hone in on what's most important in the case. For example, a lot of litigation cases, civil litigation cases, it's tried in the depositions.
Right.
So what are those key depositions you need first
Well,
to help evaluate?
I mean, you want the people that are witnesses that have factual information. You want people that are going to be able to authenticate certain information or documents or so forth. But I think what you want to do in a deposition, what I like to do is I want to develop information. I want to get testimony on the record that I can use in the future to help in a mediation, to help in a motion, or to help in the courtroom. So I'm not interested in showing all of my cards. You know, I'm not interested in saying, well, you know, I want somebody to commit to a position. So if they say, no, I've never been arrested for fraud, thank you. Okay, I know you've been arrested for fraud, and I'm going to use that in the courtroom, not now. I'm not going to give you a year to prepare to how you're going to address that and explain it in court. I want you to commit to certain positions, and that's what I'm trying to do in a deposition. I think that is the way to go about that. You know, I'm also, you know, I try to work with industry professionals and, you know, develop a rapport so I understand the industries. I mean, I'm doing a lot of construction litigation. I'm doing professional liability. Right now, a lot of attorney malpractice, a lot of insurance brokers, E&O cases, and so forth, both in New Jersey and in Pennsylvania. And you know, you need to sort of understand the industry. For instance, in construction, we're doing a lot of work with the General Building Contractors Association in Philadelphia. Mark Pillinger did a training presentation for them. I'm going to be doing something in the future. We've written some articles and so forth. So, you know, you sort of understand the industry. You have to understand the language, understand what to look for, the terms, the phrases, and you start working with these people and understanding that kind of thing. Professional liability is very personal. We understand that, and those are the cases that quite often can go to trial because they have a consent clause and they don't want to settle or something. It could be very personal. But you know, what we do is things change. There's different types of mass tort litigation that come up. Asbestos 20 years ago was big. Now it's not, because they bankrupted so many companies. So, you know, we do, and I do, insurance-based or self-insured defense litigation in all kinds of areas. Commercial landlords, big retailers, self-insured corporations, trucking lines. It just varies, but you know, it all has the same basic skills are involved and all the basic considerations. What I like to try to avoid doing is I don't want to tell a client what they just want to hear. You know, I'm sorry, I'm not going to tell you that I'm going to file this motion when I know it's a waste of time and it's going to hurt you in some ways. Sometimes you can file a motion, lose the motion, and they use it against you. I'm going to tell you the things that maybe you don't want to hear, but you need to hear.
That's exactly what I tell my clients. I'm going to tell you what you need to hear, not what you want to hear.
Exactly, because you're doing no one a service by just yesing them. And look, the clients are sophisticated claims people generally. They need to understand, and they do understand, that there are exposure in all cases. There is always a chance of a runaway verdict.
Well, and people think they know what a jury's going to do. The one thing, if you've been a trial attorney, is you never know what a jury's going to do. You put a number of people in a room together, you can have the best evidence in the world, all of these exhibits, you still don't know. Because their life experience, no matter how much you want to say, it comes into whatever it is they're doing when they're looking at that case.
That's absolutely true. And the thing is that if you base a settlement value or an assessment or a strategy on the idea that you could have a runaway verdict, like you get a lot of the thing, oh, in Philadelphia, you know, the juries are crazy. They're just going to knock and award this and that.
You can't think like that.
And I'll talk about that in a minute. But you know, you're going to overpay in every single settlement. And every sophisticated claims professional understands that you can always get hit big on a case. As long as they're aware of the fact that, you know, there's that potential, we need to look at where the median potential is.
What is your range?
Right, and nobody wants surprises. So yeah, if a case that should settle for $20,000 ends up with a $300,000 verdict, that's a runaway verdict for that case. And on the other hand, there are cases that I've had that, you know, I could say $7-8 million is not an unreasonable number for the damages. No surprises, but you can't base settlements on the chance of a runaway verdict. They're going to happen every once in a while, not a lot, but it's going to happen.
Well, you can't be afraid to do what you need to do,
right?
Which is sometimes test the case, because you're not going to always know. We were talking about jury verdicts, and we were talking about what people normally say about verdicts in Philadelphia. What is your philosophy on that?
Well, first of all, I mean, I've been hit with an $18.5 million verdict in a case. Okay, I mean, I know what it's like to get big verdicts. However, I thought the case was worth $50 million. It was a very bad med-mal case with a child that had a heart transplant and a stroke as a result of the delay in surgery. So it was bad. So I know what it's like to be hit with those cases. But look, the reality is, what I've found with Philadelphia juries is that, yeah, you can get, the numbers are going to be higher on average than some of the counties and some of the other places. The same way that, for instance, Essex County in Newark, they're going to have higher verdicts than they're going to have in Monmouth County. I mean, it's just the way it is. But there is a decent chance of defense verdicts and lower verdicts in Philadelphia as well as other places. I find that more and more. And people say, well, you know, the economy and inflation and so forth, that the numbers are going to go up. I mean, I think that the average number of a verdict is probably going to go up a little bit, but I feel that there are people sort of get it, that there's really a finite amount of money involved in a case, and there's only so much to go around. So I think they're more inclined to really look at cases a little harder and give out money fairly and not just throw money at cases. I really think that. Now, it can happen. I mean, it happens, but it's rarer and rarer. So I think that's a little bit of a myth. I mean, there are bad verdicts in Philadelphia. There's certain counties in Texas that have terrible verdicts, but it's going to happen.
But to tar Philadelphia, the
Yeah,
same
I mean,
broad brush.
the point is that if
Yeah.
you have an attorney that comes in, a plaintiff's attorney, and says, these Philadelphia juries, just present your case and don't tell me that. I know what Philadelphia juries are. I've gotten plenty of defense verdicts with Philadelphia juries, as well as other juries in New Jersey and other places of Pennsylvania. I go all over both states. And it happens, but with the right cases, you can win the case. And it's interesting because, they talk about the science of jury selection and so forth, and a lot of it's just the gut, to be honest. I mean, like the show Bull, which I don't really watch. I mean, the name fits because that to me is just, it's not realistic. A lot of it is guts and instinct in picking a jury. But do
you think that that's true for different types of cases?
Sure, and you have to tailor your case and who your parties are and what's going on, absolutely. But I found that jurors, they'll ask, have you ever been a plaintiff in a lawsuit before? This and that, these types of things. I actually had a case in which a woman had been seriously injured and had recovered in a plaintiff's lawsuit, and I questioned her and followed up and got a sense of things, and I thought, she's going to be a good juror for me because I had a plaintiff who was grossly overreaching on her damages and injuries and also had a questionable liability case. So my thought was, you were legitimately injured. So you're not going to be very sympathetic to somebody who's trying to make money when they're not injured. You're taking that chance away from somebody else. And and the jury was out for 5 minutes with a defense verdict.
It's interesting because the plaintiff's attorney was probably like, wow, you were a plaintiff in a lawsuit. They're all automatically, therefore you should stay.
Absolutely. And when I talk to some of the jurors, and it's good if you have a chance to talk to jurors, it's very instructive. And it was absolutely that way. She had no sympathy for somebody that was trying to work the system. She was legitimately hurt, I could tell that, and she was legitimately compensated. So, sometimes the formulas have to vary very much by the case and by a feel for things. I don't like to have people that are potentially leaders on a jury. Because it's dangerous. Have somebody that's like a...
Because you think everyone's going to follow.
Yeah, is whatever they are. Because, everybody's going to follow them in some way. Now, every once in a while, an attorney slips on a jury, and that's dangerous too, even if they do something else, because everybody's going to ask them legal questions. They're going to say they won't, but they're going to ask them legal questions.
And if it's not their area of law, the problem is that they're going to look into them as the expert.
Absolutely. So, it's not a science picking the jury as much as an art and a feel and an instinct and so forth. And look, sometimes you get surprised and you think you have the greatest juror. They've watched you the whole time. You're doing a closing and they're going...
They're shaking their head at you.
They're shaking their head, and you're like, and then they burn you. That happens. But on the other hand, usually you can get a pretty good feel, and you realize, this is going well. I'm going to get a good result here. So yeah, it varies by jury, and you have to think about, tailoring your whole presentation and your whole case based upon who you're representing, who the plaintiff is, who the other attorney is, and so forth. It can't just be lockstep and rigid.
Well, I think that people may make the assumption that you're coming in and doing the same thing. Well, every case is different. Every fact pattern is different. All the witnesses are, in the way that they present themselves, are going to be different. There's no same in trial law at all. There's no
absolutely, and people
case.
Need to understand that, and young people need to understand that. I've trained a lot of younger attorneys. And I'm very interested in having more young attorneys come to me for training, and we're trying to find more and more people that are interested in that, because I think that there's a value in that, in second seating somebody and in watching what's going on and so forth, because it's the next generation. And they need to understand that it's not just a matter of going through the questions and this is what you do. You have to change it. It's sort of like...
it's also key, look, when you're cross-examining someone, you could have spent the night before, you have 50 pages of cross-examination ready to go. The person gets on the stand, and you're like, we're going to set this aside, and then you start, because the key to being a trial lawyer is listening.
Absolutely.
Listening.
Absolutely, and you'll see somebody ask a question, and they get an answer, and the answer is very damning, and they just go to the next question on the paper. and they don't even realize
They
what
said
the
they
person
said.
just said. You know, they just roll right over it, and you see that, and you're like, what is going on? Fine for me, but I mean, you know, you
Yeah.
need to pay attention and sort of go down that road and follow up on what they just revealed.
And
It's
don't
not
get stuck on that
necessarily planned.
script.
No, yeah, don't be stuck on the script at all, and don't just. I sit as an arbitrator in Philadelphia and some other places, and you know, you see people come in and they have the same approach to every case. And honestly, particularly some defense attorneys, younger ones or even older ones, that everybody's a fake, everybody's a fraud, everybody's I'm going to go after them, I'm going to go after them. Well, they're not all fakes
Yeah.
and frauds, and you need to tailor your case accordingly. You know,
It's more at that point, if you know that there's risk here, there's definitely some, you know, liability issues here, you just got to know what your range is. What is your range?
Right.
How can we make it a smaller range?
Right, and you know, where do you go with your defense in a case? You know, during the break, I was saying my philosophy of trial is twofold: psychology and presentation. Okay, let's assume you understand the rules of evidence and the law and so forth. That's fine. That's an assumption. So then, going forward, psychology and presentation. So I'm looking at a case. How can I present this case to a jury in a way that's going to be palatable to them? Okay, if it's a clear liability case against me, I'm not going to waste a lot of time making up ridiculous arguments because the jury's just going to get upset and they're going to punish me. On the other hand, if it's just a case where the damages are the issue, oh yeah, you know, it was a rear ender, but the guy didn't have any injuries, I'm going to focus on the damages. If it's a sympathetic plaintiff and the attorney is being obnoxious, I'm going to focus on that attorney and not on that plaintiff. On the other hand, if a plaintiff is really just lying about things, I'm going to go after them.
Where is the weakness?
Yeah,
Where is that
exactly.
weakness?
So you have to just look at it in that way. And I say when I see people as an arbitrator and they're cross-examining a little old lady on stuff, you know, as opposed to some guy that's clearly lying. I mean, you have to figure out who, you know, change.
But that also
You have to
sometimes
change.
is not looking at both sides.
Right.
Because one of the key things you always have to do is look at both sides. You
Right.
have to look at both sides and play it out. Okay, so where's my weaknesses here? Let me play out what's going on. If I'm on the other side, what am I saying? How am I questioning that person? What is it that I would present to come against myself?
Yeah, and so just don't make up ludicrous arguments. If the damages are clear, I mean, I don't talk about present cases, but I've had a lot of cases where the damages are horrific, okay? I'm not going to stand there and try to cross-examine somebody on their damages when they're severely disabled.
It's not gonna
I'm
help
going to
you.
focus on liability and try to just, you know, make it a little more level and ask the jury, I'm going to ask you to do something very difficult. I want you to put aside this damages before you get to that and look at this. I mean, you have to figure it out. That's the psychology part. The presentation part is there's a lot of things in it. You know, first of all, I learned this in some ways. When I was at Penn on Christmas break, I got called as a juror in Philadelphia. And I sat on a jury for about a week. The case settled ultimately, but I talked with a lot of the jurors. Jurors have an expectation of attorneys to present in a certain way, okay? They want to see attorneys that are dressed properly and dressed well. They want them to speak well. They don't want them to be too argumentative. They expect them to really look like very successful professionals. You know, so that's really part of it. It's a very big expectation, and it makes a big difference. Because why are you going to believe somebody that looks like a failure? Why accept that?
Well, you can't. You don't feel like you can trust the person.
No, not at all. I mean, you know, to go in an anecdote. My father and grandfather were both pharmacists, and my grandfather was a doctor, and they had a commercial pharmacy in South Philadelphia. And my father would always say he always had an Oldsmobile, and he'd keep it for maybe 10 years, keep it nicely, and he'd say, I'd always have an Oldsmobile, and the doctors will have the Cadillac. The expectation is you're providing services and goods to a clientele, a working class clientele. You have a decent car, but if you have a Cadillac, or in this case, you know, the doctors have a Mercedes, you look like you're really taking advantage of the public.
Yeah.
Whereas doctors, particularly like for Italians, the doctors were viewed, they should be driving a new Cadillac or a Mercedes or whatever. At the time it was the Caddies and Lincolns. You know, so that's the perception they have. Right or wrong, that's a perception and an expectation.
And I don't think that you can ignore that. And I think What's interesting to me and what you said to me from the beginning of this is that your background and why you became and got interested in this, you have a theater background.
Right.
I always tell people trial law is you are writing, directing, and acting out the play. You're the director, you're a producer, you're writing, and you're acting out that play in that courtroom. You're the one who's writing the script. You have all of these facts, and how is that going to be played out in front of this juror? And that's what you've been doing for this, over 250 cases,
right,
which is crazy. If someone wanted to get a hold of you, Ernie, and retain your services to speak to you, how would they do that?
Well, they just have to go on our website, Pillinger Miller Turallo. You can see me on there, and feel free to email me. My email is there. It's ebernabei@pmtlawfirm.com. But it will also be on the website. Check us out. We have news articles, seminars, and so forth as well. But I'd love to hear from people who have questions, who are interested in representation, and anybody that has a legal question in my field. I would appreciate that and welcome it.
Thank you so much for joining me. It's
Thank
been
you.
a pleasure.
Thanks for having me. Appreciate it.
This is Justice for All. I'm Rebecca Berger. We'll be back next week.